So the topic for today is appointment of judges to the Supreme Court of India. Appointment of Supreme Court judges. We know that the Collegium system has been in the center of controversy from a long time, but we should also know its history, how it originated, what was the form of appointment of judges before the Collegium system, and why that form was brought into practice in the Indian Constitution by the Constitution framers. So, let us just see this topic in its entirety, and we shall start from the Constituent Assembly. See, first thing is Supreme Court. If we see, this is the apex court, the highest court in India. This is the apex court, the highest court in India. The Indian judicial system, if we see, Supreme Court comes at the top, then comes high courts in different states, and then the lower judiciary. So the judgments of the Supreme Court has to be followed as precedents by all the other courts, but that does not mean that Supreme Court has an administrative power over the high courts. It is, although the apex court, the highest court, and India has an integrated court system, but the administrative control of high court is in its own hand, not with the Supreme Court. Now, talking about the appointments, several countries were considered, such as the United Kingdom and the United States, and their model of appointment of judges by the Constituent Assembly while making the provision for appointment of judges in India. In United Kingdom, what happens is the king, or for that matter the queen, appoints the Supreme Court judge, and this appointment is made by the opinion formed by the Council of Ministers. That simply means executive holds a great power in appointment of judges in the United Kingdom. The Council of Ministers sends a name to the king, and the king has to appoint that person to the post, appoints the judge. So, if we see, there is no check and balance in this case. The Council of Ministers, which is the executive, holds the total power in its hand to appoint the judges. This thing was followed in the United Kingdom till 2005. In 2005, a National Judicial Commission was formed, which has several dignitaries inside it, which helps in the appointment of the Supreme Court judges. When it comes to the United States, the process is quite cumbersome. The judge is appointed by the President in the United States. What happens is the Senate is consulted by the President for the appointment of the Supreme Court judges. What usually happen in this process, here it was the executive which has the overriding power. Here it is a cumbersome process. It is a cumbersome process. It can take days for one appointment. Second thing, that the problem of political appointment can be a big issue here, because the Senate has members who have been elected from the political parties having political ambitions, and if such a party decides on the appointment of judges, sometimes the considerations can be political in nature. To avoid both these conditions, one is of cumbersome and political nature, and second is of overriding power of the executive, the Constituent Assembly in India, while drafting the constitution, have went with a very balanced approach of having checks and balances. The Supreme Court of India The appointment is seen under Article 124 Clause 2, where the appointment is made by the President. When it comes to President, we all know that it is the Council of Ministers whose decision goes to the President, and President has to abide by it, because this is a parliamentary form of government and President is only the head of the state. President appoints the judge in India with the consultation of Chief Justice of India. So, in the United Kingdom model, where the Council of Ministers was sending its opinion to the king and king was appointing the judge, in India one more category is added, that is the consultation with the Chief Justice of India. This is the part of judiciary, this is the part of executive. So, there is check and balance in the whole process and no arbitrary power, no arbitrary or absolute power. Power is given to one organ of the government. In that case, it was the executive. So, Article 124, this is important. Now, let us come to a sort of a timeline from where we can go one by one on watching how this process of appointment of judges to the Supreme Court of India has changed over a period of time, how the Collegium system was established and what are its nitty-gritties. So, in 1958, Law Commission report came. This Law Commission report of 1958 talked about the Chief Justice of India and its appointment. Historically in India, after the constitution came into force, the senior most judge of the Supreme Court, the senior most judge of the Supreme Court became the Chief Justice of India. But this Law Commission report said that the Chief Justice of India should not be only a competent judge, but he should also be a competent administrator. He should also be a competent administrator. That is why it has recommended that choosing the senior most judge of the Supreme Court of India as the Chief Justice of India should not be the only way. There must be other ways which could be found, and it should not be the only way to appoint the Chief Justice of India. But no action was taken on this 1958 Law Commission report till the coming of Indira Gandhi. In 1973, something happened. This tradition was broken down by the government of Indira Gandhi when Justice A.N. Ray, who was fourth in seniority, was appointed as the Chief Justice of India. He superseded three senior most judge of the Supreme Court and became the Chief Justice of India. Tradition was broken here. The government said they have just followed the report, they have accepted the recommendation of the 1958 Law Commission report, but nobody bought this. Everybody knew that it was a political appointment. Then again in 1976, Justice Bag became the Chief Justice of India, superseding Justice Khanna. Justice Khanna was the senior most judge at that time. He was superseded by Justice Bag. Again, the tradition was broken in 1976. Again, the 1958 Law Commission report and its recommendation was cited as the reason. But from 1978 till date, this tradition where the senior most judge of the Supreme Court is appointed as the Chief Justice of India is continuing. In 1978, Justice Chandrachud, who was the father of the now Chief Justice of India, D.Y. Chandrachud, has become the judge of the Supreme Court because he happened to be the senior most judge at that time, and this process is followed till date. Then in 1987 another report came, and this was the report of Law Commission. Again, 1958 one report came, then in 1987 this was the 121st report of Law Commission. Till now, no change has been done in Article 124 and its interpretation 102, which says that it is the President who appoints the Chief Justice of India, and other Supreme Court judges, and it is done on the consultation of Chief Justice of India. If he has to appoint a Supreme Court judge, then the Chief Justice of India should be consulted, and other judges of Supreme Court and High Court which he deems necessary must be consulted before appointing the Supreme Court judge. When it comes to the Chief Justice of India and the appointment of Chief Justice of India, he consults the other judges of the Supreme Court. And when it comes to the appointment by a President, simply Council of Minister is in play here. Council of Minister recommends the name and it goes to the President, and he consults the Chief Justice of India for the appointments and other Supreme Court judges and High Court judges which he deems necessary. And this was the process followed. In 1987, in the 121st report of the Law Commission, it was said that executive have overriding powers. Executive, that simply means what? Council of Ministers here, the Cabinet Ministers, Council of Ministers, the say of the Prime Ministers, the executive holds overriding power in the appointment of Supreme Court judges. This is against the principle of separation of power. Separation of power. This is against the principle of separation of power, and some change is needed. But again, 1987, no change came in that year, but this Law Commission report became the basis for the next three important judgments of the Supreme Court, which has not only defined the Collegium System in India, but has also shifted the balls in the favor of judges from the executive in the matter of appointment of the judges in the Supreme Court. Now coming to 1991. 1991 was an important year when a case called Subhash Sharma versus Union of India happened. Its judgment, it was a three-judge bench which gave the judgment that the primacy must be given to the Chief Justice of India when appointing the judges to the Supreme Court of India. That simply means under Article 124 Clause 2, when the President appoints the Supreme Court judges, he or she consults with the Chief Justice of India. But this consultation is mandatory? Is this consultation mandatory? That simply means if Chief Justice of India says to appoint person A, is the government or the President, it is binding on the President to appoint person A? Is it mandatory or not? This was not defined or not interpreted till this 1991 Subhash Sharma case, that whether the consultation is mandatory. That simply means the consultation can be read as concurrence or not. So, the whole process of appointment of judges shifted in favor of the Supreme Court judges from the hand of the executive. This was an important case which interpreted the word consultation and said that the primacy must be given to the Chief Justice of India in consultation, and it said that this goes on with the principle of separation of power. It also said that Supreme Court does very important role, it plays a very important role. It protects the fundamental rights of the citizens. In a federal polity, it is the one which solves the problem between the center and state and between states and states. Since we have a written constitution, to maintain the supremacy of the constitution is the work of the Supreme Court. When Supreme Court plays such an important role that it is the major interpreter of the Constitution of India, the appointment of its judges cannot be handed over to the executive. It has to be in the hand of the judges themselves, that will maintain the separation of power in the whole system. Separation of power simply means that one organ does not hamper the independence of another organ of the polity. With Subhash Singh case, another important case after this case came up, which was in 1993. The 1993 case, which is called as the Supreme Court Advocate on Record Association versus Union of India. Advocate on Record Associations and few of the lawyers associated with it filed a petition raising several questions in the appointment of judges of the Supreme Court. A 9-judge bench gave the order. 9-judge bench gave the order. In Subhash Sharma case, it was a 3-judge bench. Subhash Sharma case, the judgment also said that the matter must be consulted to a larger bench. So here it was a 9-judge bench which gave the order, and it again reiterated the decision made in the Subhash Sharma case, which says that the primacy must be given to the opinion of Chief Justice of India, because the Chief Justice of India is in the position to know the competence and worth of any judge more than anybody in the other organs of the government. Hence, it is important that the Chief Justice of India and his opinion must be given the primacy. But this judgment also came up with a very important interpretation that Chief Justice of India and his opinion doesn't mean the opinion of an individual. Now here the word collegium comes. Here the word collegium comes to play. That simply means when Chief Justice of India is forming his opinion, he should consult the senior most judges of the Supreme Court. Chief Justice of India, while forming the opinion, must consult the senior most judges of the Supreme Court, and when this opinion is delivered to the President shall make the appointment. So the power to appoint the judges has been shifted from the Council of Ministers into the hand of Collegium. This was a major shift in the Constitution of India. Article 124 has now been started to be interpreted in a very different way. The word consultation here has now been converted into concurrence, and this consultation became mandatory. Also, another important point which was raised in this case of 1993 was that all the recommendations and all the opinions of the judges, the senior most judges and the Chief Justice of India must be made in writing. It must be made in writing. It also raised another important point that no absolute power has been given to any organ of the polity of the government, and that is why to appoint the judges of the Supreme Court, it is not only the Chief Justice of India whose opinion matters, but of the Collegium. In a similar fashion, the Chief Justice of India and his Collegium does not hold the absolute power. It doesn't hold the absolute power, but there is a trick here that if the government, if the executive comes up with some strong reason, whether a person should not be appointed as the Chief Justice or whether a person should not be appointed as the judge of the Supreme Court, then that strong reason must be conveyed to the Chief Justice of India, and if the Chief Justice of India accepts that reason, that particular name would be dropped. But if Chief Justice of India reiterates that name, then the appointment must be made in the healthy fashion. Again, talking about Collegium, in the same case it was said that if even the half majority of the Collegium refuses to appoint a name, the Chief Justice of India must not consult that name and must drop that name. Also, it is said that if the Chief Justice of India gives his personal opinion to government, the government must not consult it, the government must not send a report to the President, and it is only after the consultation of the Collegium in writing that the opinion must be sent to the President and the appointment has to be made. So this was an important judgment which has defined how the judges must be appointed in India. Then came the year 1998. 1998 was an important year because in this year the government has taken presidential reference. Government can take an opinion from on any legal question from the Supreme Court of India under Article 143. This is called as presidential reference. So government took the presidential reference on the appointment of judges. The Supreme Court in 1993 under this presidential reference has elaborated the whole process of collegium, and it said that the collegium must contain of Chief Justice of India and 4 senior most puisne judges. Puisne judges. What does the word puisne means here? Puisne simply means judges of the highest rank but below the Chief Justice of India. So Chief Justice of India plus 4 senior most puisne judges will be forming the collegium. And even if 2 judges refuses to appoint a person to the post of the Supreme Court, then the name must be dropped. So it is the process of consultation which takes place in the collegium. Then that consultation and that opinion is sent to the president for appointment. Now we are here in year 1998. Something important happens in the year 2002. In the year 2002, National Commission on Review of the Constitution gave its report. It said that the appointment of the judges of the Supreme Court is a major concern, and a National Judicial Commission must be formed. The National Judicial Commission must be formed, which can consist of several dignitaries such as the Vice President of the country, the Prime Minister, the Chief Justice of India, plus the 3 senior most puisne judges. It can also have law minister in it. Now we see there has been a shift here. Earlier, the power to appoint judges were in the hand of executive. Then this power got shifted in the hands of collegium because of the 3 judgments which we have just now discussed. The Subhash Sharma in 1991, advocate on record case in 1993, and presidential reference in 1998. This power to appoint shifted from executive to collegium. Now, with the recommendation of the National Commission for the Review of the Constitution, it was said that a National Judicial Commission must be formed, which must contain judges and other important dignitaries such as the executive plus the opposition also. Here the leader of opposition in Lok Sabha and Rajya Sabha, leader of opposition must also be considered as a member of National Judicial Commission. Acting on this recommendation of the National Commission on the Review of the Constitution, government came up with a National Judicial Commission Act. The NJAC in 2014. it was the 99th Constitutional Amendment Act. This was the 99th Constitutional Amendment Act, which defined how the Supreme Court judges and the other High Court judges were to be appointed. But this step of the government was quashed. This step of the government was quashed by the Supreme Court, citing the reason that law minister and the eminent jurist who will be the member of the National Judicial Appointment Commission, the act gives them the veto power. That simply means without their green signal, the person will not be appointed as the judge of the Supreme Court. Somebody's name can be forwarded or somebody's name can be taken down. It gave the veto power. That simply means this eminent jurist was to be appointed by the government, and law minister is also the part of the government. So it gave a sort of a veto power to the government. We came from the system where executive have the power, then the power went into the hand of Collegium. Now Supreme Court interpreted that again the power was to be shifted through the Nazak Act in the hands of the executive. Hence, citing the basic structure of the Constitution and separation of power, which is an important element of the basic structure of the Constitution, the Supreme Court of India has quashed the National Judicial Appointment Commission Act, which is the 99th Constitutional Amendment Act. Hence, the system of collegium in India stands as it is, which was made by the three important judgments of the Supreme Court. Hence, as of now in India, it is the Collegium of Chief Justice of India with 4 senior most puny judges who select and appoint the judges of the Supreme Court. That simply means if any vacancy is formed, it is the Chief Justice of India who initiates the process of appointment. First selection and then sends the opinion in writing to the government. From the government side, there is a background check, and then the government sends this recommendation to the president. Now a new problem is arising when, and this has become a news few days back, that when the opinion of the collegium is given to the government does not act upon it, and the government sits on that opinion, not appointing the person to the respected post. Hence, this has become another problem and a tussle between judiciary and the executive. Thank you very much for listening.